Hi, everyone. Okay, it looks like we still have quite a few people coming in. I know this was directly after the Community of Practice meeting. So I really appreciate you all being here immediately after that meeting. Still stalling just a little bit, but I'll go ahead and get started as people trickle in. Well, hello, everyone. Welcome to today's National NAGPRA Program webinar. My name is Kate Compton-Gore, and I'm the training coordinator for the National NAGPRA Program. Before we get started, I'd like to remind everyone that this webinar is being recorded, and the recording will be made available on our YouTube channel. And we will provide a link to that YouTube channel as well. For those of you who regularly attend our webinars, we have transitioned to Teams webinar platform. And after the presentation, we will turn on the Q&A where you can write questions for live responses. And Melanie O'Brien, the National NAGPRA Program Manager, and other members of our team will be available to assist during the Q&A. So I'd like to announce that we have updated our trainings page on our website, and all webinars from 2024 and 2025 and so far through 2026 are listed with a link to the recording on YouTube. We will not be hosting webinars in July and August, but will return in September for our fall series. I'm actively working on the fall series, so if anyone has topics of interest that you'd like to see a webinar on, please let us know. Today's webinar is on repatriation, including the definition and process, and the notice process, including submitting big notices. I want to address the language that I'll be using today in this webinar, which follows the regulatory language. However, we acknowledge that some terms may be offensive and other more culturally sensitive terms may be preferred by tribes, communities, and individuals. And we advise you to discuss preferred language during consultation. Okay, so I'm going to start my presentation. All right, so today's webinar will focus on the definition of repatriation and the steps in that part of the process, and information related to notices, including ways to simplify the notice. Many of you on here today have worked with me one-on-one or another member of our team, and we remain available to answer questions at nagpra_info@nps.gov. So here I'm going to talk a little bit about our website and some updates. Again, I mentioned that we have made some updates to the trainings page, and you can get there by navigating to the nps.gov/NAGPRA and navigate to the Getting Started tab, Reference Library, and then Training, or you can visit our Events tab located at the bottom of the homepage. We also, exciting, we have two new databases. We have a grants database and an unclaimed lists. So again, if you want to navigate to those, you can get there on our webpage through law and policy, and then databases. So those are the announcements that I wanted to make. So today we're going to start with the definitions that will help clarify the meaning of repatriation. Here's a screenshot of the table of contents from the regulations, and you can see that the definitions are in 10.2. I'm going to go over possession or control, custody, and then repatriation. And please note that the definitions are directly from the regulations, and all additional definitions can be found there as well. As museums and federal agencies continue to move through the NAGPRA process, we are receiving more and more questions related to these topics I'll be discussing today. So possession or control. This is the definition pulled directly out of the regulations. I did try to break it down so we could talk about it, and I can really focus on certain sections here. But possession or control means having a sufficient interest in an object or item to independently direct, manage, oversee, or restrict the use of that item. So a museum or federal agency may have possession or control regardless of the physical location of that item. And this came up in a question yesterday, actually, about that the item was located in a different place, but that museum did have possession or control, and they wanted to make sure. In general, custody through a loan, lease, license, bailment, or other arrangement is not a sufficient interest to constitute possession or control. And so again, I want you to pay attention to that. So if you have possession or control, then you have the possession or control, and the custody is not a part of that. And so it resides with the leasing, loaning, licensing, bailing, or otherwise transferring museum or federal agency. We get asked a lot of questions about what possession or control is and what it's not. And it's the legal responsibility to items and therefore requires going through NAGPRA. It's up to the museum or federal agency to determine if they have possession or control. And as stated in the definition, it is not dependent on where the item is physically located. If you continue to have questions about this definition, please add them to the Q&A at the end. Custody, on the other hand, means having an obligation to care for the object or item, but not a sufficient interest in the object or item to constitute possession or control. In general, custody through a loan, lease, license, bailment, or other arrangement is not sufficient interest to constitute possession or control, which resides with that loaning, leasing, licensing, bailing, or otherwise transferring museum or community. As an example of custody is a museum holds a federal agency collection, and while that museum does have responsibility to care and safeguard that collection in its custody, when it comes to NAGPRA, the responsibility lies with the federal agency in this example. And that is the agency who has possession or control. Repatriation means a museum or federal agency relinquishes possession or control of human remains or cultural items in a holding or collection to a lineal descendant, Indian tribe, or NHO. This is the final process of NAGPRA. We continue to see misunderstandings and incorrect assumptions related to the repatriation process and definitions, and I will spend some time going over this today. The purpose of NAGPRA is to protect and restore Native American human remains and cultural items. And you can see this in 10.1A1. And under NAGPRA, repatriation equals the restoration of rights. Oh, actually, I want to go back for a second. Let's see if it will allow. Here we go. I want to go back to repatriation. So I looked up the definition of repatriation in the dictionary, and among different examples, it generally said that repatriation means to send home. And while many examples refer to the physical transfer, under NAGPRA, this is not how it is defined. So while NAGPRA requires the return of Native American human remains and cultural items, it does not define to include physical return as part of repatriation. The purpose, as I said, of NAGPRA is to protect and restore Native American human remains and cultural items. If you search for physical transfer and repatriation in the final rule, you will find many references to this. So although right of possession does not come up often, it's important to understand the definition. Right of possession is possession or control obtained with voluntary consent. A museum may have possession or control of an item, but it does not necessarily determine that they have a right of possession. The terms right of possession and possession or control often get mixed up, and so I urge you to go into the definitions in 10.2 and really look these over. When a museum chooses to assert right of possession, they are also asserting that they are not repatriating. You cannot assert a right of possession and repatriate. And again, you can find examples of the right of possession in final rule. And Tanner, if you could go ahead and link that for us, that would be fantastic. Additionally, further discussion on the right of possession is in the summaries webinar from June of 2025. Tanner's going to link the final rule so that you all can refer to that while I'm going through this webinar. But again, in the summaries webinar specifically, I'm going to be talking a lot about this in a few minutes. And then there's also the inventories webinar from 2025 as well. And keep in mind that items made for sale or trade may also meet the definition of a cultural item, depending on the specific circumstance of that item. Traditional knowledge discussed during consultation will help identify any items that the museum may not know as a cultural item, or should not have, or does not have, possession or control, and right of possession. Okay, so now that we've gone over some of the definitions, I'm going to begin halfway through the regulatory process for cultural items, including unassociated funerary objects, sacred objects, and objects of cultural patrimony. For additional training on the steps for completing the inventory or summary, please visit our YouTube channel for those videos. So this is the table of contents from the regulations. And again, we're focused here on the repatriation subpart. 10.9 is where we're starting. The repatriation process for cultural items under 10.9 begins with a request for repatriation in step 4. At this point, the museum or federal agency would have completed steps 1 through 3. We begin with step 4, receive and consider requests, move on to step 5, respond to those requests, then submit a notice of intended repatriation, which includes subsequent publication in the Federal Register. And finally, step 7, the submission of a repatriation statement to National NAGPRA. And as previously stated, for information on steps 1 through 3, I will not be going over that today. So step 4, receive and consider a request for repatriation. At any time, after a summary is compiled, a lineal descendant, Indian tribe, or NHO may submit to the museum or federal agency a written request for repatriation of unassociated funerary objects, sacred objects, and objects of cultural patrimony. A request for repatriation must be received by the museum or federal agency before sending of a repatriation statement for those cultural items. For purposes of calculating timelines, a request for repatriation received before the deadline for compiling a summary is dated the same date as the deadline for compiling a summary. And that information is also, I'm going to say that one more time, and I'll say it again when I'm going through inventories. A request for repatriation received before the deadline for compiling a summary is dated the same date as the deadline for compiling a summary. Requests from 2 or more lineal descendants, Indian tribes, or NHOs who agree to a joint repatriation are considered a single request and not competing requests. So here's the criteria pulled from the regulations. A request for repatriation must satisfy the following criteria: that each cultural item meets the definition. The request is from a lineal descendant, Indian tribe, or NHO with cultural affiliation. And the request must include information to support the museum or federal agency does not have a right of possession to those cultural items. And you can go and look at this yourself in the regulations if you'd like to spend more time with this. I pulled it directly out. So for step 5, the museum or federal agency has now received a request for repatriation for cultural items. No later than 90 days after receiving a request, the museum or federal agency must send a written response to the requester and a copy to any other consulting party. Using the information available, including records, existing studies, and results of consultation, the museum or federal agency must determine if the request satisfies the criteria. There are 4 possible responses. For repatriation of cultural items, there is a requirement to show cultural affiliation and that the object meets the definitions. So the request meets the criteria. The request does not meet the criteria, and the museum or federal agency must provide explanation for why and provide an opportunity for the requesting party to provide additional information. The museum or federal agency can determine that the request meets the criteria, but the museum or federal agency is asserting a right of possession and is refusing repatriation of the cultural items. At this point, the museum must provide information to prove that they do in fact have a right of possession. And 4, the museum or federal agency has received competing requests for repatriation and must determine who the most appropriate requester is, utilizing the information in the regulations. For this step, Indian tribes and NHOs may continue to track the response due date, may request a repatriation statement by a certain date, prepare a response for additional information, and prepare to challenge the museum assertion of right of possession. And at this point, explore joint requests and other resolutions. This, we have a template that is still in the works and that is forthcoming. But please note if a museum or federal agency can go ahead and create, and do, we get many of these, create a response letter without waiting for our team to develop a template. Okay, so now we're to step 6. No later than 30 days after responding to a request for repatriation that meets the criteria, a museum or federal agency must submit a notice of intended repatriation. This is also referred to as an NIR, so Notice of Intended Repatriation. The Notice of Intended Repatriation must be sent to all requesters, any consulting parties, and to National NAGPRA per publication in the Federal Register. The notice must include the abstract of information from step 1 when you initially compiled your summary, the number and brief description of the cultural items, and these can be in lots rather than an individual count. You must identify the lineal descendant whose name may be withheld, Indian tribe or Native Hawaiian organization who is requesting repatriation, and the contact information. Information that is not required are things like site numbers, accession information, and other detailed information about the individual items. Indian tribes may search the Federal Register for information on geographical location or acquisition history. Additionally, tribes may search the Federal Register for the name of other tribes or NHOs and prepare for competing requests and the date of the repatriation statement, as long as it is not earlier than 30 days after publication. So here's our template for a notice of intended repatriation. And this is for cultural affiliation. We also have one for lineal descendants, which I don't have here today. In this template, you must follow the Federal Register guidelines very closely, and so please pay attention to the instructions when using this template. So in the previous example, I said that you could create your own letter. This is an example of where you must follow those guidelines very carefully. If a notice does come to us with errors, then it can delay the publication of the notice, and we will return that to the museum or federal agency for corrections. The first page is the instruction page, which clarifies that this notice is only used for unassociated funerary objects, sacred objects, and objects of cultural patrimony. And it's only used after a request for repatriation has been received, and they have responded to that request. On page 2, you can see that there are examples of each type of cultural item, including unassociated funerary objects, sacred objects, and objects of cultural patrimony, and those that are both sacred and patrimony together. You will need to include the relevant information for the objects that you are including in this notice. And one of those, I just want you to pay attention here. I do get asked regularly if something can be both sacred and patrimony, and yes, and there's an option for it here in the template. Okay, so we've arrived to step 7, repatriation. No earlier than 30 days, but no later than 90 days after publication in the Federal Register, a notice of intended repatriation, the museum or federal agency must send a written repatriation statement to the requester and to the National NAGPRA program. Under the new regs that were published in January of 2024, that went into effect in January of 2024, we now require a repatriation statement, and it must be sent to National NAGPRA program and the requester. A repatriation statement relinquishes possession or control of the cultural items to the requester, which may include the lineal descendant, Indian tribe, or NHO. And in the case of joint requests for repatriation, a repatriation statement must identify this and be sent to all requesters. After sending a repatriation statement, the museum or federal agency must consult with the requester on custody and physical transfer. Document any physical transfer and protect sensitive information as identified by the requester from disclosure to the general public to the extent consistent with the applicable law. After a repatriation statement is sent, there is nothing in the Act or this part that limits the authority of the museum or federal agency to enter into an agreement with the requester concerning the human remains, consuming the cultural items. Indian tribes and NHOs may continue to track the date when they receive the repatriation statement, determine how physical transfer will occur and any specific details, and identify what information needs to be protected. This is the information that I just discussed on the previous slide, but it's directly from the regulations itself. And like I mentioned, after a repatriation statement is sent, there's nothing in the Act or that limits the authority of the museum or federal agency to enter into an agreement with the requester concerning physical transfer. And concerning physical transfer, please note that a museum or federal agency cannot require lineal descendants, Indian tribes, or NHOs to countersign the repatriation statement. We continue to receive information that some museums are requiring tribes and NHOs to sign the statements, but that is not required under the Act and cannot be used to delay submission of the repatriation statement. Here's an example of, well, here is our template. It's not an example, it's the template. This is a very straightforward document. On the first page, it has the instructions and requirements for the document, and the second page is the template ready for you to insert your information. A repatriation statement is required, but museums cannot require certain actions post-repatriation because they no longer have possession or control. And I want to be very clear here that physical transfer does not equal repatriation. It may be determined in the process that the lineal descendant, tribe, or NHO is ready to immediately receive the items, but this is not always the case. And so I advise you to consult about physical transfer during consultation and throughout the process. Okay, so moving on to inventory requirements under 10.10 of the regulations for Native American human remains and associated funerary objects. And again, I'd like to remind you that for additional training, please check out our webinars. So here we are in the table of contents again, but we've moved to 10.10. The repatriation process for Native American human remains and associated funerary objects under 10.10 of the regulations begins with a request for repatriation in step 6. At this point, the museum or federal agency would have completed steps 1 through 5, and published a notice of inventory completion in the Federal Register. For information on those steps, please see the regulations. Today, I'm going to begin here with step 6, receive and consider requests, and then step 7, respond to requests, and moving on to step 8, repatriation. After publication of a Notice of Inventory Completion, or NIC, in the Federal Register, any lineal descendant, Indian tribe, or NHO may submit to the museum or federal agency a written request for repatriation of human remains and associated objects. A request for repatriation received by the museum or federal agency before the museum or federal agency sends the repatriation statement for those human remains and associated objects. For the purpose of calculating timelines, a request for repatriation received before publication of a notice of inventory completion is dated the same date as the notice was published. And so similarly as in the summary section, I'm going to repeat that. For the purposes of calculating a timeline, a request for repatriation received before publication of the notice in the Federal Register is dated the same date that the notice was published. And that's how you can address that, those requests that come in early. And I want to take a moment to go over this example because this is not uncommon for tribes to request during consultation and before the notice gets published. And that's where you can line it up with those dates. So if during consultation, a tribe requests repatriation, during consultation, so earlier in the steps, if a tribe had requested repatriation, you can decide the best option for writing that request down. Some examples have included using meeting minutes, sending an email, and writing it down on a piece of paper in that moment so that you can capture that request right then. Once your notice of inventory completion has been published and you already have a written request, that step is complete. So I hope that helps clarify that. That comes up as questions quite often. Indian tribes or NHOs who agree to joint repatriation are considered a single request and not competing requests. The requester is identified in the notice of inventory completion, and the requestor is not identified in the notice of inventory completion. And the request shows that by a preponderance of the evidence that the requester is a lineal descendant, Indian tribe, or NHO with cultural affiliation. And so again, even if the tribe was not mentioned originally in the notice, they can come forward with information. So what happens if a notice is published and no request is received? The museum or federal agency waits for a request. They can continue to reach out to consulting parties, and it will care for the ancestors under duty of care, and the museum can wait for a request for repatriation. This is where the timeline depends on Indian tribes or NHOs to act, and there is no timeline for that to occur. There is no deadline for that to happen. So here's the template for a request for repatriation. We are also working on a sample letter for museums to respond to a request. Please note this letter is assuming the requester is identified in the notice. So I had mentioned that it is possible for the requester to not have been identified in the notice. This example is showing the requester was identified in the notice. If the requester is not identified, additional information is required to show how the requester is affiliated. And in this notice, this is again one of the examples where all of the information explains what needs to be included, and then the example of what you need to include. So now we've arrived to respond to a request for repatriation in step 7. A template is also forthcoming. Please note that a museum or federal agency can go ahead and create a response letter without waiting for our team to develop that template. And remember that you're under a deadline. No earlier than 30 days after publication of the notice of inventory completion, but no later than 90 days after receiving a request, a museum or federal agency must send a written response to the requester with a copy to any other party identified in the notice. Using the information available, the museum or federal agency must determine if the request satisfies the criteria as identified in step 6. And remember that criteria that we just mentioned is in the previous step. Indian tribes or NHOs may request that the repatriation statement is completed by a certain date, prepare a response with additional information, and explore joint requests and additional resolutions. Okay, so now we're on step 8, repatriation. No later than 90 days after responding to a request for repatriation that meets the criteria, a museum or federal agency must send a written repatriation statement to the requester and a copy to the manager at the National NAGPRA program. After sending the repatriation statement, the museum or agency must consult with the requester on custody and physical transfer, document any physical transfer, and protect sensitive information as identified by the requester. And as the same with summary items, after the repatriation statement is sent, nothing in the act or in this part limits the authority of the museum or federal agency to enter into an agreement with the requester concerning the human remains or associated items. So here's our template for a repatriation statement. This is the only document that is required for us. Some museums have presented to tribes with additional requirements or additional paperwork to sign. And that is not something that tribes have to comply with. Only this is what is required to satisfy the repatriation requirements. There we go. So I've included this example here of repatriation statement. We recently received this one. I redacted the identifying information, but this follows the required format as detailed. And so I thought this would be really helpful. We get a lot of questions asking us what is an example of a repatriation statement. So I'm including one here. And again, museums can't require certain actions post-repatriation because they no longer have possession or control. Once the repatriation statement is submitted, the possession or control is now with the lineal descendant Indian tribe or NHO. And this is where all the details about physical transfer can happen. And that may or may not occur. And so again, if you have questions about this, we can go over it in the Q&A a little bit more coming up. Okay, so let's shift to the next portion of the webinar that will focus on notices of inventory completion for human remains and associated funerary objects. So we're sticking with 10.10 of the regulations. Go big when the ancestors go home. So I'm going to go over this slide, but publishing a notice of inventory completion, but publishing a notice of inventory completion, you must submit the notice of inventory completion, or NIC, to the National NAGPRA program, and there we've included our email here. The notice must conform to the mandatory format in the Federal Register and include the required information. And again, we have the templates. I've listed where they are located on the website. No later than 21 days after receiving the notice, the manager of the National NAGPRA program must approve for publication in the Federal Register any submission that conforms to the mandatory format and requirements, or return to the museum, federal agency, or NHO any submission that does not conform to those format or requirements. No later than 14 days after the submission is returned, the museum or federal agency must then resubmit the notice to the National NAGPRA program. So again, that's why I keep urging everybody to really pay attention to those requirements and how the notices come to us. And I want to emphasize the role of the notice. As the title suggests, the notice is to notify Indian tribes and Native Hawaiian organizations that an inventory for the Native American human remains and associated funerary items has been completed, or that a request for repatriation for cultural items has been made. So those are the purposes of the notice. It's a document required for the tribes, NH and NHOs, and lineal descendants to make that request for repatriation. The museum or federal agency may include in one single notice of any human remains or associated funerary objects having the same determination of lineal descendant or cultural affiliation. And this is what we mean by go big. And remember, there is a 6-month timeline for museums and federal agencies to submit a notice of inventory completion after submission of the inventory. So what if something changes after publication of a notice? And this again comes up often. So I'm going to go over each of these pieces today. Let's say that the museum or federal agency finds additional ancestral human remains or cultural items. Well, you begin with step 1, and this will ensure adequate consultation and notification that occurs prior to repatriation. And we're talking about new collections. What if a museum or federal agency, and I know this is hard to say this, but finds additional parts or elements of previously identified ancestors and items? Well, those must be, it depends. So those can be transferred to the appropriate lineal descendant Indian tribe or NHO without the publication of a notice. But that also requires consultation if you have questions about if this is additional ancestral human remains or if these are additional parts or elements. And so if they are part of things that were of people that were repatriated, you can transfer those to the tribe. If you have more questions about this, please ask us. What if there's a change in cultural affiliation determination or requesting parties that were originally listed in the notice? Well, that is where you can submit an optional amended notice, but only if it's requested by the consulting parties to add or revise the lineal descendant Indian tribe or NHO. That is only if it's been requested. The repatriation statement will actually identify who the items were repatriated to, which is why it doesn't have to be changed in the notice. The notice is not the final piece. The final piece is the repatriation statement. And I want to reiterate that the notice is this legal process for tribes to make a request and get to the repatriation step. The notice is not the last step. The last step is the repatriation statement, which again addresses any of these changes. The notice does not impact possession or control. That also comes with the repatriation statement, where it is officially transferred to the lineal descendant tribe or NHO. And keep in mind that after the publication of a notice, any lineal descendant Indian tribe or NHO can come forward, even if they were not originally listed in the notice. The repatriation statement will show again who that was repatriated to. And the 30-day waiting period allows for other tribes and lineal descendants to come forward. So big notices, there has always been an opportunity for big notices to be published. There's nothing in the Act that prohibits this. For example, including all sites in a state or region, or including all ancestors in a single notice. There's nothing in the Act that states that museums and federal agencies must submit several notices if one is best. How a notice is produced will be a combination of how the information, your information in the museum or federal agency or institution, how that's organized within your institution, and what the preference is by the tribes, which can be discussed during consultation. So again, consultation, consultation, consultation. You as a museum, so this is similar to discussing the preferred timelines with the tribes, that the museum may have the information organized in a way that can encourage big notices, but it should be discussed with tribes during consultation because that might not fit their preferences. The purpose of the information here today is that big notices, big consolidated notices are an option. We do come across many museums. I'm still talking to museums that think that each notice, that there has to be a separate notice for site or a separate notice for individual tribes. So I do have an example I'll use. We recently received, there was an example where four notices that all contained the same tribes that were listed culturally affiliated, and the only difference in those four notices was that they were by the region in a specific state. And so that would have been a really good example for that institution to combine all of those into one. However, there was information given to us that the tribes had requested that the notices be divided into region because that was how they preferred it, and made it easier and less of a burden moving forward. And so in that case, it was an example where one notice would have been great, but the tribes requested four. So something to think about. And Tanner, Tanner has an example of a recently published big notice that we are going to link for you to be able to look at. You can also search in the Federal Register notices by the number of individuals and look for other examples of this. Thank you, Tanner. Okay, so here we are. We're going to go ahead and open up the Q&A for your questions, and we will answer them live. And I will have Melanie O'Brien and Tanner. I'm not sure if anyone, and I think it's going to be Melanie and Tanner and I answering your questions today. So thank you all for being here for the presentation. I'm going to stop sharing. Okay, so if anyone wants to post or ask a question, please, now is the time to do that. Okay, let's see. In regard to 10.93I, request must satisfy each item meets the definition. A museum receives competing requests of differing definitions of the cultural item. Who holds more weight to the definition of the cultural item consulted on, the tribe or lineal descendant, especially where tribes have historically passed laws on the definition of the item? Melanie, would you like to take this first one, please?
Hi, everybody. Let me just read the question again and make sure I understand. A museum has received competing requests for different definitions of cultural items. So, for example, a request for a cultural item as a sacred object might be one, and then from a lineal descendant, and then an Indian tribe has made a similar request for repatriation of the same cultural item as an object of cultural patrimony. Who holds more weight to the definition of the cultural item? So who gets to decide whether it's an object of cultural patrimony or a sacred object? Well, ultimately, it is the museum that makes the decision in all cases in NAGPRA. That decision-making responsibility is with the museum. And the museum must evaluate those requests for repatriation and make a decision about which request has satisfied the criteria, which request shows that it is a sacred object or an object of cultural patrimony, and the museum must make a decision. The museum can make a decision that it's received competing requests and it can't determine who's the most appropriate requester. That's an option, but that's still the decision that the museum has to make.
Thank you, Melanie. And I think I'm going to have you take the next one as well, which is how does the reversal of the Chevron decision affect NAGPRA compliance, especially duty of care?
Well, I appreciate the question. And the Chevron decision is a specific case that relates to specific regulations. And it does not have an impact, as far as I understand, on the NAGPRA regulations or the revisions of those regulations in 2024. The Chevron case did not speak directly to the NAGPRA regulations.
Thank you. See, next question, relative to the notice of inventory, does this refer to the entire museum collection or subsets of related types makers? I think, I think maybe you're referring to the, yeah, the notice of inventory or a summary. Melanie, I'm thinking that this is referring to a summary.
No, it says a notice of inventory completion, so that would be human remains and associated funerary objects. I think the question, does this refer to an entire museum collection or subset, is the question of how a museum decides to divide its notices, which is related to the concept of big notices. So it is up to the museum to decide how to organize its inventory and what groupings to put in a notice. So it could refer to an entire museum collection, or it could be divided into discrete pieces depending on the museum's collection, the information about the collection, and then, as Kate mentioned, the consulting party's preferences.
Okay, thank you. Next question, is a museum required to describe the nature of associated funerary objects in an itemized list, inventory, or notice of inventory completion? I see the templates referred to type of object. Are we required to include descriptors such as lithics, pottery, beads, shell, etc.? Or if the nations request that the information is not included, do we defer to their request? Well, when you create your initial list that you will use to initiate consultation, you will put the information that you have available to you. So you can list out what those associated funerary objects are. During consultation, you can discuss with tribes how they would prefer those to be identified moving forward, and how those are identified in the notice as well. Did I leave anything out that you'd like to add, Melanie?
We'll just say that you're correct. The template and the regulations require the notice and the inventory to include a description of the cultural items or the, excuse me, of the funerary objects. And that is a requirement. It is required to describe the type of funerary object. How that is described, there is some flexibility there, and certainly the level of detail is subject to the museum's decision on how it represents that detail. And of course, they should take into consideration the tribe's request. But there still needs to be some kind of description, and let me explain why. Because it could be the description of a funerary object that would provide the information another party would need to determine that they are culturally affiliated with those same ancestors and objects. So that's why that's a minimum level of information that is required in a notice. We've seen funerary objects be described in lots of different ways. And I think you can look at examples of notices to see very detailed, very specific descriptions or more generalized descriptions. And certainly there are many ways to generalize a description, but still provide that description.
We have an answer to, we answered the question related to the notice of inventory and then collections or subsets. And then we have a correction or an additional that says yes for a summary relative to cultural objects, for example, mission baskets. So I think I understand the question that you're asking, and that's, will they be subsets of your collection? So a museum or federal agency is required to submit a summary of any potential cultural items that could be in your collection. We have examples of the different types of templates or summaries and the way they're written. So it really determines what about the knowledge that you have on your collection. So if you have if mission baskets are potentially cultural items, but perhaps you don't know this, you include them in your summary so that Native American tribes can come forward and say, we'd like to look at these mission baskets. Some of those may be sacred. So you can include those as part of your general summary. You can list specifically, we have 100 mission baskets, or we have 100 baskets that you've identified based on some information who to send those summaries out to that could be culturally affiliated. So if mission baskets could be potentially culturally affiliated to one specific tribe, then it can depend on how you would describe that in your summary. So the idea was for a museum to submit one summary that was a general description of that collection, and that would not be updated. The only time you would submit a new summary would be if your collections changed, if you acquired new collections or items that are outside of that original general summary. So I hope I answered that correctly for you as the second part of that answer. Okay, let's see. I'm gonna give me a moment while I uptick. Okay, under 10.9, steps 1 through 5 are challenging for our federal museum. We must share information about objects and consult with tribes to identify NAGPRA cultural items. Coordinating and funding travel to conduct tribal collections review is not funded as a line item. Can agencies, bureaus support tribes to apply for NAGPRA grants to identify NAGPRA cultural items? Melanie, would you take this one, please?
Sure. Again, 10.9 means we're talking about the summary process for cultural items. So not human remains, but cultural items in 10.9. And as Kate just described, the first step is to create a summary, which is a general description of your collection. Step 2 is to invite consultation, and that is the last required step under 10.9 until you receive a request for consultation or a request for repatriation. So I just want to be clear that, steps 1 through 5 is a lot of different steps. And the trigger for those steps largely comes from the tribes themselves making either a request to consult or a request for repatriation. And it sounds like what you're getting at here is that consultation requirement and the ability of your institution to fund that tribal collections review or consultation. Tribes can certainly apply for consultation or documentation grants to conduct those consultation visits. There are limitations when we're talking about a federal collection, though, because again, the responsibility there for a federal collection is on the federal government, and NAGPRA grants cannot be used to fund federal government responsibilities. There's some, there's some room there in respect to what if the tribes are making the grant application and to clarify why the federal agency cannot support the work. But I also want to say that there are lots of other ways of conducting consultation that maybe would not require the same level of funding. And that can be, depending, of course, on the tribe's preferences, it could be photographs, written descriptions of objects, Zoom calls where you go over the collection or review objects. Those are all options for conducting consultation on summary items that may be a little more economical.
Thank you. Next question. I just wanted to note the timeline for notifying all parties of a competing claim is 14 days. It's much shorter than most of the other timelines within 43 CFR part 10. Almost missed that one. Yes, well, it's short because, I mean, essentially, if you get a competing claim, then that letter should or could go out in a day. But we have given museums and institutions 14 days to go ahead and notify all parties of a competing claim. So that's why that deadline is shorter. It's a response.
And it is just it's just to inform the parties that there are competing requests. That's the only thing that has to be done in that 14 days is let everybody know this has happened. The decision on the competing request, you have 180 days to make. So just keep in mind what we're talking about here. The 14-day requirement is just to let everybody know you have competing requests. You then have 180 days, which is nearly 6 months, to make a decision about who is the most appropriate requester.
And we do get, if you have more questions about that, about competing requests, you can go ahead and put them in the Q&A today, please. I'm going to go to the next question. I seek clarification about joint claims. When an institution submits an inventory and NIC, which includes various culturally affiliated tribes, then the tribes submit a joint claim as a request. Does the written repatriation statement include all tribes on the notice or through consultation? Does the institution and tribe decide on the lead tribe? Well, yes, I do believe that that it can be decided who is going to be the primary contact for a joint repatriation, and both parties would be listed on the notice and it would be described in the abstract as a joint repatriation.
I think the question here, Kate, is about the repatriation statement, not the notice. So,
oh, thank you. Written repatriation statement. Okay.
If you look at the text for a repatriation statement in the regulations, it says that the statement must identify the requester. So if there are multiple requesters, it would identify the multiple requesters. And that's the only requirement there. So anybody who submits a request, including those who make a joint request, would be listed in the repatriation statement.
And this also could be used as an example of perhaps maybe they weren't included in the notice, but then if there was a joint repatriation, they would both be identified in the repatriation statement. So we could track that. Going through, let's see. Oh, here why all these time deadlines? Oh, and Tanner has a question, but Melanie, would you like to answer the question on why all these time deadlines?
I hit the wrong button. I don't have a question. We're good.
Oh, okay.
Sure, I'll try the best I can to answer your question about timelines. You know, that the purpose of regulations is to provide a process by which these things can move forward. As many of you know, NAGPRA was passed in 1990, so it has been a long time that this process has been in the works. And in revising the regulations in 2024, one of the main objectives of those revisions was to include clear timelines for museums and federal agencies to complete certain steps in the process. So where there are clear timelines and definitive timelines, it is for museums and federal agencies to provide information and to make decisions. And so that's the purpose of those timelines, is so that it can then facilitate the options for Indian tribes and Native Hawaiian organizations to make requests or to decide what their actions are going to be. I want to stress that there are no timelines or requirements on Indian tribes or NHOs to make requests for repatriation. But there are timelines and requirements for museums and federal agencies.
Thank you, Melanie. And Lisa just posted that you can send any NAGPRA questions at any time to us at nagpra_info@nps.gov. We are all on hand to answer these questions as they come in, and we get to them pretty quickly. So please take advantage of that option to send us questions at any time. You don't only have to do it during the webinars. I'm going to uptick. Okay, I think I have answered, looks like we've answered all the questions. Tanner, are there any that I missed? We still have time. I've allocated an hour and a half, so we can take all of that time if we need to. If you'd like to continue writing questions. And if you'd like to ask us any other questions, as you know, take advantage of this time to have all of us on at once to answer these. So please take the advantage of using the Q&A here today. It doesn't even have to be related to the specific topic if we've moved on from those questions. Okay, did I hear correct that we can write down the verbal request to 10.9D step 4, or does it have to be a formal written request from a tribe? A request for repatriation needs to be written down, but it doesn't need to be in a specific formal format. Those come in different ways. The main piece is that there is a request in writing from the tribe for repatriation. And then that starts. And then again, if, for example, during initial consultation, one of the tribes makes a request, then that's where it can be written down and then held and then dated on the date that the notice is published. Pretty
Yeah,
much
I'll just add
sorry.
that there's flexibility right here to accommodate different circumstances in how that request for repatriation gets written down. I think the important part is that everybody agrees that it is a request for repatriation. So if there's a discussion during consultation, it would, the museum should confirm that this is a request for repatriation. I'm going to put it down in writing, and everybody agrees to that. You might even want to send a follow-up meeting minutes or some way of recording that request for repatriation. But there is great flexibility here for museums to provide that service or support to tribes in making that written request for repatriation.
And just adding on to that too, this makes me think how we've really, well, Melanie really has made this to where it's very flexible. When these regulations were being written, to allow for different ways for tribes to be able to communicate what their requests are. Really, the formality is when we describe in those templates, when you're sending documents to be published in the Federal Register, those must adhere to very strict guidelines. But as you'll notice as you're going through the steps, there is a lot of room for varying ways of accomplishing these steps in the little intricacies of them anyway. And in fact, we get a lot of questions, which is why for those of you who've worked with us for a while, you'll see that each question is answered individually. Because there are so many differences and little intricacies between institutions and the tribes they're working with, we do cater those answers for questions like this. So thank you for asking ones like that here. Okay, the next one. Can the request be a follow-up email from the federal agency back to the tribal nation noting the request during a meeting? Yes. That's another way that the federal agency could reach out and say, did I hear you make a request? Would you like this to be a written request? Absolutely. Let's see, when will the NOFO for NAGPRA grants be announced?
I typed the answer, but I'll say it for those who are listening. We do not have any information on when the notice of funding opportunity will be published.
Okay, let's see, we are caught up with questions. Like I mentioned at the beginning of the webinar, I'm working on the fall series right now. And so you can put something in here. We always ask for anyone to bring up anytime what they'd like to see a webinar on or specific information on. Sometimes I base my webinars from questions we receive. And so it's a really good way that the more questions that come in, I can see where museums and federal agencies are in the process overall. We do see a shift moving through the regulations as the time goes by. And so I do try to capture that information. Let's see, can you talk a bit about found in collection items and possession or control from a museum perspective, i.e. moving forward with a NAGPRA process with ambiguous info? Yes, I can talk about this. I'm trying to think about found in a collection. Well, even with very ambiguous info. So again, if we back up, if we're talking about finding an item in a museum collection. So you have an item in a museum collection that you think may be a cultural item, or perhaps it's an associated funerary item, or if it's Native American human remains, obviously that's much more straightforward to know that you move through that process. But you take the information that you have available. So you can, if you have absolutely no provenance or provenience information on the item, then that's where geographical location can come in, and understanding your collections. How were your collections amassed? When was your museum, or when did collecting start? Who were the collectors? Where the location of the collection is, or where the found item can also be used in determining, okay, well, we know it's located in this town, in this state, and so we can start with the tribes that are close by. When it comes to possession or control, I'm going to have Melanie kind of jump in at the end of this, but it's up to the museum to determine if they have possession or control. If you have an item that was found in your collection and you don't have any information that it belongs to a federal agency or that it's on loan, then the possession or control would be, or well, the museum could make the determination that they have possession or control and are going to move forward through NAGPRA. If the museum does not have possession or control, then the question is, well, then who does? And so I see this as kind of a two-part question. Melanie, I'll let you jump in.
Sure. I think you're spot on, Kate. You said exactly what I would say. David Tarler, who used to work for the National NAGPRA program before he retired last year, would always say the answer to who has possession or control can't be I don't know. You have to determine who has possession or control. So if it's not you, who is it? If you don't have any information to show that it is somebody else, then it is very likely yours. You really want to look for information to show it's not yours, and then figure out whose it is. In the absence of that, then you should proceed as you have possession or control, and proceed with the NAGPRA process.
Thank you. Next question. I am consulting for the first time and I have a question about non-response from tribes after multiple attempts to contact. Is it typical, if the consulting parties agree, for the non-responding tribes to still be listed as affiliated on an NIC? You know, this is interesting. In the community of practice call just before this, the THPO was explaining that sometimes she gets, I think it was 500 to 1,500 emails a week. And so if tribes don't respond, that's not a non-response, or that's not an answer, or that's not a determination. You can continue to reach out to tribes in different ways. But still, and then if it's an NIC, so the museum or federal agency does have a responsibility to publish a notice for human remains and associated funerary items. And so based on the information that you have, you would then keep a record of consultation, and you could show no response. But again, it sounds like that you're continuing to attempt to reach out to the tribes, but then you can publish that notice with the tribes that you feel are culturally affiliated. And at that point, during the 30-day waiting period is where additional tribes or lineal descendants can come forward, or you can move forward in that way. Now, for some reason,
suggestion I'm going to add,
please, Tanner. Yes.
In the community of practice meeting today, there was mention that there are some tribes who just don't have contacts for this type of thing. Sometimes that happens. And then tribes also have websites. So if you're not getting contact in one way, then go to their website, see if you can contact a front office or something, and they'll direct you to where you need to be.
Thank you, Tanner. Nice to have you jump in. And anytime, please. It's nice. I think it's nice to have answers from multiple, from all of us on the team. Let's see, can you go over again when we request signatures for repatriation, such as the transfer of control document after the notice expires? So we require a repatriation statement, and that repatriation statement will be submitted to National NAGPRA, but it does not require the tribes to sign, or excuse me, to countersign. So that repatriation statement will be sent and does not require signatures, counter signatures. I'm wondering, anyone have anything to expand on that? Okay. I was told MOUs were not legally binding. Do you have any guidance on how to establish in writing a long-term care agreement after repatriation occurs? So that is outside. So once repatriation, once the statement has been signed, then that has completed the NAGPRA process. Melanie, is there anything that you can offer about this?
Again, as Kate said, because the regulations govern the process through the repatriation statement, we don't have any specific advice for you here, but this is a great question to ask of the NAGPRA community of practice. Certainly, there are multiple instruments that museums use for long-term care agreements. I think depending on the circumstance of your institution, you should hopefully be able to find some kind of instrument that you can enter into that long-term care agreement. I think there might even be some examples of care and trust agreements, which is an instrument some museums use in the NAGPRA Community of Practice share files. So again, this would be a good question to ask of other museum practitioners and how they have managed this process.
Oh, and it looks like there was a comment. Thank you, Shaylee. Perfect. Yes. So in that asking about MOUs. Okay, that's all the questions we have right now. Going through to check comments to see if I missed anybody's. Okay, well, I'll give it a couple more minutes to see if we get any more comments in the Q&A. So while I'm waiting, I will just say again that we will have this posted, this link. This will be uploaded to our YouTube. It may be uploaded to the YouTube channel faster than it shows up on our website on the trainings page. And so if you are looking for it on the training page and there's no link, we will have a link there. But do continue to check the YouTube channel for this webinar to be posted. Okay, Melanie, do you have any final things? Oh, here we got a new one. Okay, great. Please keep them coming. Will the fall sessions you are planning start in September? Great, thank you. Yes, we will be having sessions in September, October, and November. And this month, as you all here know, that I changed the date because it would have been last Friday, which landed on a federal holiday. But we will return to the third Friday of the month. I will check those dates. I will aim for those dates unless other things come in place that we have to alter. Okay, another question. Oh, can you please explain about joining the community of practice? Let's see. Tanner, would you like to, or I mean, I guess, let's see. Looks like somebody's already commented. A link, perhaps? There we go. Yes, thank you, Melanie and Shaylee. You can click on the link to join the community of practice.
I had just copied the link to come back and find my job was already done.
You can also just Google NAGPRA Community of Practice, and it's the first thing that comes up.
And also, please tell, I've been working to expand these webinars into additional listservs to get to people who are both experienced. I do plan these to be both experienced in NAGPRA and those who are just starting. So always feel free to let your colleagues know about these. And if there's a listserv or an organization that you think would be benefit that we could reach out to, please also let us know. That's something you can send us. We are a small but mighty team, as I've heard Melanie say many times, but we do look at every email individually. And so that's a really great opportunity to engage with us about topics that, of ways that we can expand these webinars out to more people working with NAGPRA. Okay, I feel like I'm going to start an auction going once, going twice. If anyone else has any questions, we'll wait another minute. I don't know, Melanie or Tanner, does anyone have any more comments or announcements? Okay, well, without any more questions, oh, we got a question. Let's see. If ancestors have been repatriated, but the claimant tribe wants to wait for transfer, is there reporting? Finally, thank you for all your help. If the ancestors have been repatriated, but the claimant tribe waits for transfer. So there isn't reporting, correct, when that transfer is complete, because once the possession or control has been turned over to the tribes after the repatriation statement, then it really is up to the museum to determine that in with the tribes. The only time that we require notification of a transfer is in a different in 1010K of the regulations. Correct?
There's no requirement in NAGPRA for any additional reporting after the repatriation statement is sent. But there may be other reporting or care requirements that either the federal agency or a museum might have for objects that are in its collection that it does not have possession or control of. So I will just say that there's nothing in NAGPRA, no requirements in NAGPRA, but that doesn't mean there aren't other requirements out there for items in a collection.
And then I'm looking, Tanner, let's see, don't forget to the chat is disabled for the webinars, but Tanner did put a couple of links in the chat that you should be able to grab out of there, which has a link to the final rule and the example of the big notice, one of the big notices in our discussion today. Okay, everyone. Well, I don't see any more questions, but I want to thank you all for being here today for another one of our webinars, and we will all see you in the fall, in September. Thank you so much. Take care.